How many people are truly prepared to move forward and take the next step in whatever the situation is? How many of you all are ready to go and perform or have a uh, to do an oral argument? Because depending on where you are, oral arguments are going to be um, in front of 3-judge panels. Like in Florida, if you have a child support issue, oral arguments in child support issues have the you're required to um submit your notice of oral argument. You're also required to give them, I think it's like 2 weeks notice, or 10 days after the last document is filed. And then they had to give you a sign-up date, a date for your oral argument. You go present your oral argument. Unfortunately, in Florida, they have this thing called PCA. In Florida, a PCA can essentially foreclose your ability to appeal to the Florida Supreme Court, unless the Supreme Court uses what's called discretionary review. I seem to see a lot of PCAs versus written opinions, and some of those PCAs are conflict. So I'm considering, before the appellate court rules, asking the Supreme Court for prohibition against the second DCA because of their continued deviations from well-established law. Don't forget this also, as you move forward, in order for you to exercise federal courts to say like maybe like one of your fundamental rights are violated, you're going to have to, in most instances, because you may not be able to do interlocutory appeals, depending on how your state's set up. You want to exercise all your state court remedies to say that you've tried everything within the state to get the remedy that was available at law. So just keep those things in mind.